And I'm Jeff Harrison. I'm here to get Mr. Hamilton. For some reason, I'm having a little luck with his last name. Don't ask me why. He's to my right.
All right. We are here for a final pretrial. Is there any resolution in this case?
There is.
There is, Your Honor. It's my understanding that the defendant will be guilty to count one. In turn, the people will dismiss counts 2 and 3. The people are also recommending fines and costs as well as community service.
That is my understanding as well.
Mr. Hamilton, have you heard what the attorneys have said the resolution to this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Other hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
It's my understanding that you'll be pleading guilty to count number 1 of abandoning or cruelty to one animal. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100. I'm sorry, $1,000, up to 200 hours of community service or any combination thereof. In exchange for that, the people will be dismissing count number 2 of unlicensed dog, that is a 3-month misdemeanor, and count number 3 of failing to keep the animal vaccinated. That also is a 3-month misdemeanor. Additionally, there's an agreement that you have with the prosecutor that they will recommend fines and costs and community service only as a sentence.
Yes, sir.
Now, do you understand that that's your agreement is that they'll recommend it, not that I will follow that? Do you understand that?
Yes, sir.
If I decide that I'm not going to follow that recommendation, you would not be able to withdraw your plea. Do you understand that as well?
Yes, sir.
Back on September 16th of last year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you remember reading and signing the advice of rights form that talked about your rights to an attorney and your rights to a trial?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial in this case, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order for you to plead? Has anybody threatened you in any way?
Yes, sir.
And is it your own free choice to plead today?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
Where?
I am likewise unaware.
Then, Mr. Hamilton, to the allegation that on or about September 16th, 2025 in Boone Township of Wexford County, how do you plead to count number 1 of abandoning or cruelty to one animal? In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on September 16th?
Oh, my wife and I, well, soon to be wife, we're actually currently, going through a divorce. And she was like the stay-at-home mom, getting the kids off and on and the bus and everything. I've worked 50+ hours. And the dogs did have dog food at the house.
Okay. Want to help, Mr. Harrison?
We're talking about a dog named Loki. Are you familiar with Loki?
Yes.
You don't have Loki
No,
anymore.
I do not.
Why is that?
When the animal shelter came out and picked him up, she signed off all the rights to the dog when I was at work.
And she would be your soon-to-be ex-wife.
Yes, she will be my symbiote.
Is it your understanding that the dogs were underfed and malnourished or anything like that?
I mean, yeah, I would feed them when I get home, but after, like, when I go to bed and get up for work, I don't know what happens at the house after that.
Was there a period of time where you weren't at this residence?
No, I go there at night to sleep because that's my current residence.
What is this residence?
It'd be the house out in Boone
Okay,
Township.
did the judge already ask you the address?
No, nobody asked me.
Okay. I couldn't remember whether you had said that or not. Okay. So do you agree with the idea that Loki in particular was greatly underweight,
Yes.
malnourished,
Yes.
and was emaciated and in not in very good shape when animal control visited the residence?
Yes, I was.
Okay, would you agree with me that you had a responsibility to care for this animal?
And yes, I do, and I should have taken better care, more, took more steps to help this animal out, but
Would it be safe to say that you were negligent in that respect, at least in terms of the seeing that the dog had appropriate care?
yes.
Thank you, Your Honor. I believe that's a factual basis.
Ms. Lawrence, do you agree?
Yes, Your Honor.
Mr. Hamilton, I guess I got a little confused through there a little bit. You were living at the residence at the same time that this was occurring?
Yeah, like, I was only, because I would go there, just practically sleep, because I was working a lot of hours, so I wouldn't be getting home until like 7, 8 o'clock at night. And I would have to be back at work at like 1, 2 o'clock in the morning. So I was only there for maybe 5, 6 hours at night, and that was it.
And I think I heard you answer to one of Mr. Harrison's questions that you would feed the dog?
Yes, I would feed them when I get home,
Okay,
because they did have dog food at the house.
okay.
So why she wasn't feeding them, I don't know why I was at work.
And did you physically see the dog while you were feeding it?
Yes, I did, because I would, pet him and stuff when I got home and when I fed him.
And during that time, could you see the condition that the dog was in?
I mean, yeah, it's like dark because my kids were home sleeping. So when I like got home, I would feed them and pet them, like, what I mean? So like I didn't turn every light on in the house when I got home.
And if I understood you correctly, you said that your wife at the time signed off the rights to the dog?
Yes, sir. Because
Whose animal was it?
I mean, it was like mine and hers, because we
Okay.
went together to pick it up.
Okay, all right. And so this is alleged to have happened on September 16th. When was the last time you had seen the dog prior to September 16th?
I think it was the 15th is the last time that I seen them, because all that happened when I was at work.
Okay. All right. The court agrees. I do find the defendant guilty of count number 1, abandoning cruelty to one animal. I also find the plea is knowing, voluntary, and accurate. Pursuant to the plea agreement, counts 2 and 3 will be dismissed at the time of sentencing. Any allocution, Mr. Harrison?
Well, Your Honor, this is an example of things that can and do go wrong when you simply stop paying attention. And I think this is clear that that's what happened here. In the midst of their marital woes, in the midst of their determination to achieve a divorce and split up that family, if you will, it's painfully clear that Mr. Hamilton elected to bury himself in his work and to ignore the situation at home. I know he tried to equivocate, because at the end of the day, the statute has some language in it that is difficult for people to accept. Abandonment, cruelty, words like that. You heard him say this, and this is pretty telling. You heard him say, I know I could have taken better care of that dog. In fact, there were 3 dogs that were removed from the property that day for similar reasons. And there had been a complete disregard of the hygiene and other things like that going on. So it's clear to me that both of the adults, but I don't represent his putative wife, lost track of their obligations in a number of ways here. So this is a good example and a good life lesson for people that might be in a similar situation, that simply devoting yourself to 50, 60, 70 hours of work in a week does not solve your problem at home. In fact, in this case is a glaring example of it that makes it worse. I'm appreciative of the fact that the prosecutor has elected not to seek incarceration here because I don't see anything that would come from incarcerating him. At the end of the day, the dogs were turned over in effect to the animal controls, rightfully they should have been. He has told me this was an eye opener for him, and it kind of brought him to the reality that if he's going to work this many hours, he can't take on the responsibility to care for a dog right now or anyone else. He does have some self-healing to do due to the divorce and some other things. That is also pretty compelling to me in terms of the resolution of this matter as well. It shows me that the lesson was learned and he's not going to repeat this conduct again. And whatever his intentions were or are, it's just a sad situation across the board. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. As you said in the prior case, there's two sides to every story. And I do think there is a little bit more to this story, but I don't know if it's relevant to go into so much detail of that. It was clear as day that these dogs were not being cared for. This was a 5-month-old puppy that was found in a crate full of feces and urine. It was emaciated, covered in fleas. It clearly was not being taken care of. So if I'm being frank, I do not believe Mr. Hamilton was feeding this dog every day. I just don't. This dog was not being cared for, and on top of that, he was not the one to call animal control or turn the dog over. His wife at the time did. She knew that this was not okay. These dogs were not okay, and she did turn them over to animal control. I would ask for fines and costs, but I also would ask the court to impose some type of community service in this case. I do think it is warranted, given the defendant's actions to this poor animal. So I would ask the court to follow that. Thank you.
Did the wife call animal control as well, or just surrender?
There was some things going on with CPS and trying to get wife and children out, which led to animal.
Okay. All right. Mr. Hamilton, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, not at this time.
All right. The agreement in this case is that the prosecutor would recommend fines and costs and community service work, and that's what they've done. I'll be honest, the court is toying with whether I follow that or not. What I'm going to do is I'm going to set this over for sentencing. I'm going to order a pre-sentence investigation report in the meantime. Mr. Hamilton, you can go out to the front window where you checked in, get your next court date, and we'll have a packet here for a PSI to be done in just a second.
Want me to head out there now or?
Hold on just a minute. All right, court next calls the people of the city of Cadillac versus Logan Machowski, case number 254916OM. Harris's counsel.
Lawrence on behalf of people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Machowski. He's next to me at the table.
We are here for a final pretrial. Is there any resolution to this matter?
There is.
There is, Your Honor. It's my understanding the defendant will be pleading guilty as charged. There is also a killover agreement for HIDA for 3 to 6 months roughly.
Mr. Harrison?
That's an accurate statement.
Mr. Machowski, have you heard what the attorneys have said the resolution of this case is? Is that how you wish to resolve it?
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right. I need you to speak up so we can make sure the recording equipment can get you, okay?
All right.
So it's my understanding that you'll be pleading guilty to count number 1 of disorderly person. That is a misdemeanor punishable by up to 90 days in jail and or a fine of not more than $500. Do you understand that potential penalty?
Yes, sir.
Now, you also have an agreement with the prosecutor that you would be placed under sentence under the Holmes Youthful Trainee Act. What that says is that young persons basically do stupid things, and we give you a second chance. And so we put you on a period of probation. If you're successful at that period of probation, in which the agreement is between 3 to 6 months, and you're successful with that, then the charge would be removed from your public record. Law enforcement and the courts would still see it, but the public would not be able to. If you're not successful though, however, the disorderly person then could enter on your public record. Do you understand that?
Sure.
Now, do you also understand that that's an agreement you have with the prosecutor and not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, sir.
Back on November 20th, were you on probation or parole?
No.
Were you on bond? Do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you understand those rights?
Pretty much all.
All right, well, let me hit on a few of them for you, all right? Do you understand that you have a right to a jury trial, the right to have witnesses called for your defense at trial, the right to call or cross-examine all witnesses called against you at trial, the right to remain silent and not have that silence used against you, and the right to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand those rights?
Yes.
Most importantly, do you understand that you do have the right to that jury trial, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
I understand that.
Other than the agreement in this case, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes.
Are counsel aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
I am likewise unaware.
Then Mr. Machowski, to the allegation that on or about November 20th, 2025 in the city of Cadillac or Wexford County, how do you plead to being a disorderly person? In order to accept that plea, I must have you tell me what it is that makes you guilty. By reading the complaint, it looks like you were at the Cadillac High School back on that day,
Yes.
and you were looking in windows while wearing a mask.
I looked in one window. I seen my teacher.
All right. Were you wearing a mask?
Yes.
What type of mask were you wearing?
It was a bandana to keep my nose warm.
Okay. So from the way I envision it, your eyes were visible and that's about it.
Yeah, my eyes were visible. That was about it.
And why were you looking through the window?
Well, I seen one of my teachers and I waved to them because it's been a while since I seen them.
Are you a student at Cadillac High School?
No, I dropped out maybe 2 or 3 months ago.
Okay. So you were no longer a student at the time that this happened?
No.
And do you believe that your actions that day caused some breach of the peace? Caused a disturbance?
Yes.
All right. Do counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
I do.
As does the court, I find the plea is knowing, voluntary, and accurate. I will take the plea under advisement because it's not proper, I don't believe, to enter it yet, given the agreement for HIDA. Are we able to sentence today, Ms. Lawrence?
Yes, Your Honor.
Any allocution, Mr. Harrison?
Yes, I'm really impressed with Logan's communication with the court today. I don't know if the court would recall, when we first became involved with him, he was very difficult to communicate with and has slowly opened up in the intervening time period. I think that's due in large measure to the fact that he now has a stable home life. You can see the people in the gallery. They not only came with him to be with him here today, they also provide a stable environment for him and a place to live. He didn't really have that before. The reason he had gone to the school building that day was to agree to and sign some IEPs, individual educational programs, due to the fact that he has been previously diagnosed with ADHD, ADD, and at least one other thing that had represented, I guess the blanket term would be a learning disability, and it made school extra difficult for him. It also creates a scenario where, even more so than the average teenager, he sometimes lacks the ability to understand how his actions might be perceived by other people. So in his mind, he had a black bandana on his face, he was dressed all in black and had a black cap on as well. He recognized a familiar face, tapped on the window and said hi. He didn't realize that would send people scrambling for the exits and create the institution of a safety plan for the entire school building. He may have realized it shortly after it occurred, but that was not his initial thought. I think the court stated it pretty succinctly. The reason I chuckled a little bit when you said it was that's almost exactly what I said to him with regard to the HIDA designation. The courts are aware that young people sometimes do stupid things. And there's also an understanding that they ought not to suffer for that one area of indiscretion for the rest of their lives by maintaining a criminal history. I think this is a case which is a model case for what HIDA is supposed to be used for. I can't think of a better example of a case that ought to be treated and designated in accordance with that program. So obviously I would encourage the court to do so. I've explained it to Logan. He's promised to call me if he has any questions. I know his family, so there's no reason to conclude that he will have any trouble at all with the requirements of probation. He's got people in his life that are interested in him succeeding, not in maintaining or failing. And I think that's going to be important to him as we go forward as well. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. As Mr. Harrison said, Logan was wearing a black hoodie, a black baseball hat, and had a handkerchief covering half of his face. I think with certain things that happen in our society these days, we can all understand why everyone was extremely freaked out when this occurred. I think maybe this is one of those situations where he didn't necessarily think or understand maybe the gravity of him doing that and the fear that it would cause the students and the teachers inside. So I do think that HIDA is appropriate in this case, and I would just ask the court for a short term of HIDA. Thank you.
Mr. Machowski, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Not really.
Do you understand why what you did was probably not the right thing to do?
Now I do, after hearing it from other people that it was
And Mr. Harrison said you now have a stable environment.
Yeah, my sister, my mom, and the sisters. Yeah,
And what are you doing education wise now?
I am now on graduation alliance, which is a school for dropouts online.
Online? How are you finding that?
It's pretty easy for me because I get work done quick, and the school was not accommodating properly. And this school is accommodating.
Okay. Is it a work at your own pace type program?
Yeah and no. You
Okay.
get a month to complete 2 classes, which isn't too bad. No.
All right. And what happens at the end of that? Do you get a diploma or GED? What do you get? Do you
You
know?
get a diploma and then a graduation.
Nice. So what do you hope to do with yourself in the future?
Well, I'm hoping to go into my welding because I've been doing it for 4 years. I'm pretty proud of what I do.
Nice. There's always a great need for good welders out there. It's kind of a lost art form, honestly. So I hope you keep up with that. I do believe it is appropriate to sentence under HIDA. I'm not sure that there was any malintent here. I think it was just a bad choice. And I am convinced that, Logan, you've learned your lesson. And things have turned around for you. So I don't want to make things worse at all. So I will sentence pursuant to HIDA. I will do a 3-month period of probation. Because it is HIDA, you are not eligible for early release, so you'll have to do that full 3 months. But during that time, you're not to violate any law. Report as ordered to your probation officer. Keep your contact and employment information current with your probation officer, and to not leave the state without the consent of your probation officer. I'm not going to put any difficult conditions on you. I am going to require that you continue with your education. And that's it. All right. So if you can do that for the next 3 months, you're going to not have this on your record. Okay. Now there is a $75 crime victims rights fee, a $50 state minimum fee. That's all I'm going to, and 3 months of probation, which is $90. I'm going to waive the fines. I'm going to waive the court costs, and I'm going to waive the attorney fees because I don't want to bog you down with that either. You have enough going on your plate. There's no jail on this, right?
1 day.
I'm not gonna impose that yet because it wouldn't be proper. All right, so any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. I'm gonna waive that while you're on probation. All right. Do you have any questions for me about what we've done today?
No, you're wrong.
All right, I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able. If not, get set up on a payment plan. And then you'll need to go downstairs to probation to get signed up, but my guess is they're probably closed for lunch right now. So you probably have to come back this afternoon to get signed up, all right? All right, Logan, good luck. Best luck moving forward.
Thank you, Your Honor.
Thank you. And we are adjourned for the morning.
Tell us your full legal name.
All right, you may be seated. We're here for a final pretrial. Is there any resolution in this matter?
There is not, Your Honor.
No, Your Honor.
All right, so we have a tentative trial date set for February 11th. Is there any issue with that date?
Yes, Your Honor, I have a conflict on that date. Your staff was kind enough, we had a little discussion offline.
Oh,
We found a date that worked.
all right,
March
what,
13th.
March 13th?
March 13th.
Ms. Lawrence, will that date work for you as far as you know?
That's fine, Your Honor.
All right, we will set this then for a trial on March 13th. Is there anything else we need to address on the record?
No, thank you.
Does the court have a trial scheduling order it prefers to issue in terms of motions and limine and different things like that? Or
Generally, the case scheduling order issued at pretrial discusses that, so let's take a quick look here. Oh, it looks like the motion language has been taken out for some reason. I guess if you anticipate any motions, I prefer them sooner than later. But as long as we've got them heard before trial date, I'm all right with that. And then what the court usually does, I'll put together my proposed jury instructions. I send them out and then we can address those as when the need arises.
I think, I've never had a trial before.
No, right. Yep.
I just want to make sure I understand clearly, what do you expect from me leading up to trial?
Yeah, so what we do is we do jury selection the morning of trial. I usually sit 7 and then we'll choose an alternate before the jury deliberates. I usually don't limit voir dire, so I give you open grounds for that. And then from there, it's pretty straightforward. So I usually try to get the jury instructions out usually the Friday before trial, so you've got time to look at them. And then we can address, with you being away, we can do that by email if you have issues that you want to address, or we can address it the morning of. I usually bring the parties in the chambers before we start selection to make sure there's no issues we have to go over and just go from there.
Understood. Jury questionnaires, does the court send out questionnaires?
You can obtain those from the clerk's office. And you can obtain the questionnaires and then they're required to be returned back.
Okay.
Yeah. I don't know what panel we have, and that honestly is probably, it'll be a different panel than what we have these 2 months. So yeah, you can get those from the clerk's office.
Thank you, Judge. I appreciate it.
All right. Mr. Ingleson, just a reminder that your bond conditions continue. Any that you have, and make sure you stay in contact with your attorney in case anything arises between now and trial date, okay? All right, anything else for the record, Ms. Lawrence?
No, Your Honor, thank you.
All right, thank you.
Thank you for your time this morning, Your Honor.
All right, court next calls people of the state of Michigan versus Sue Ann McKinney.
Nate Carnes on behalf of the people.
Good morning, Your Honor. Michael Picknick here on behalf of Ms. McKinney, who is approaching now. Ms. McKinney, tell us your full legal name, please.
Sue Ann McKinney.
All right, this is case number 25-4348 SM. We are here for a final pretrial. Looks like we have a resolution. Is that correct?
Yes, Your Honor. It's my understanding that the defendant will plead guilty to an added count of attempted retail fraud second, and the people will dismiss both of the charged counts.
Mr. Pieknik, is that your understanding of the plea agreement?
That is, Your Honor.
You may be seated. Ms. McKinney, have you heard what the attorneys have said the resolution to this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
All right, will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. It's my understanding that you will be pleading guilty to what is essentially an added count 3 of an attempted retail fraud second degree. That is a misdemeanor punishable by up to 6 months in jail and or a fine of $1,000. In exchange for that, the people will be dismissing the completed offense in count 1, which is the 1-year misdemeanor, and count 2 of trespass. Is that your full understanding of the plea agreement?
Yes, sir.
Mr. Carnes, is there any restitution requested?
Yes, Your Honor. $703 to Walmart.
And is that part of the plea agreement or no?
Your Honor, it was not discussed.
All right.
If defense wants to set it for a hearing, I have no objection to that.
All right, I just want to make sure that that's not part of the agreement. Ms. McKinney, back on October 9th of last year, were you on probation or parole?
No.
Were you on bond?
No, sir.
Do you remember reading and signing an advice of rights form? It talked about your rights to a trial and your rights to an attorney.
Yes, sir.
Did you understand those rights?
That was a while ago, but yeah, at that time I understood.
Right. Most importantly, do you understand that you have a right to a jury trial? And by entering a guilty plea today, you'll be giving up that right. You won't have a trial of any kind.
Yes,
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
I'm sorry, sir.
Has anybody promised you anything in order to get you to plea other than the plea agreement?
No, sir.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then Ms. McKinney, to the allegation that on or about October 9th, 2025 in Herring Township of Wexford County, how do you plead to an attempted retail fraud second degree?
Yes.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on October 9th, were you at the Herring Township Walmart?
Yes, sir.
And while there, did you attempt to take property that had a value of at least $200 or more, but less than $1,000?
Yes, sir.
And was it your intent to try to take that?
It was once I was in the parking lot, yes.
What do you mean by that?
I went out to the parking lot to actually get my wallet. But then the Walmart guy, somebody, I didn't know he was a Walmart guy, was very suspicious in the fact, the way he was looking at me and everything. And so I threw the stuff in the back of the pickup and left. So I didn't go in the store with the intentions of stealing it, but once I was out there like that, I did.
Okay.
I did.
And I want to make sure I'm clear. So you must have had a cart of stuff and went out to your car to get your wallet
Yes,
with the cart of stuff.
yes,
And then somebody from Walmart either approaches you or sees you, you throw the stuff in the vehicle and leave.
basically, yes.
All right. Do counsel believe defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. McKinney, I find you guilty of an attempted retail fraud second degree. Pursuant to the plea agreement, the completed offense and the trespass will be dismissed at the time of sentencing. Are we able to sentence today, Mr. Carnes?
The people are okay with that. However, I think the defense has a request and I'll take no position.
I believe it'd probably be best if she was referred for a pre-sentence report and came back, because there's, as the court heard briefly during taking the plea, it's not as straightforward as it appears on just a limited plea sheet.
Okay.
There's a little bit more going on too, Judge, that if you're made aware of, will help you craft an appropriate sentence.
All right. Then we will set this over for sentencing and we'll order a pre-sentence investigation report. What I'll do is I will set, well, Mr. Pieknik, is there an agreement for restitution right now?
Not now, but we can work on that as well.
So what I'll do is I'll set a restitution hearing at the same time as the sentencing. That way we can handle it all together. And certainly if you guys reach an agreement to that, we can address it at that point. Let's make some notes. Okay, Ms. McKinney, you can go out to the front window where you checked in, get your next court date. Do we have a packet that we need to give her?
Yeah.
We set her next court date for February 26th. I'll be here on a final pretrial already, and the reason I asked for a little bit more time is there's some medical records that we want the sentence investigator to look at. It might take her a little bit of time to accumulate those to present it to the investigator.
Do we have time on the 26th?
Yeah, at 10 o'clock we have opening.
All right, so we'll set it for 10 o'clock on the 26th.
Thank you, Judge.
Thank you.
But then don't leave.
Did she get her packet?
Yes.
Okay.
Yeah, just wait for her to catch up.
Court next calls the people of the state of Michigan versus Catherine Emily Kuhn, case number 25-5070 SM. Appearances counsel.
Courtney Lawrence on behalf of the people.
Good morning, Your Honor. Michael Pieknik here on behalf of Ms. Kuhn, who stands to my right.
We are here for a couple of things. One is a final pretrial. We have a motion for bond, reciprocal no contact order, and the defendant has a bench warrant for a violation of the no contact order reported on December 15th through January 1st. So first of all, I guess, is there any resolution? You all maybe see, is there any resolution in this at all?
I have our final pretrial set for the 26th.
It's just.
Oh, it's just the motion? I'm sorry. Getting confused, I guess. All right, so we've got the bond violation and the motion. So I assume there's no resolution then, correct?
Correct.
All right. So let's handle the arraignment on the bond violation first. Ms. Kuhn, I have an alleged bond violation that you violated the no contact order reported between the dates of December 15th and January 1st of this year. And that was reported in a Wexford County Sheriff's Office incident report. It would be report number 83-2600011. You do have the right to have a contested hearing in this regard, in which the prosecutor would have to put on evidence and prove to the court that you did in fact violate the no contact order. Or you can admit responsibility and we would decide how to proceed from there. So let me turn to Mr. Piechnik. Have you had the opportunity to discuss the issue with your client?
Briefly.
How are we going to proceed today?
She's going to admit with explanation.
Ms. Lawrence, do you have any objection to an admission?
No, Your Honor.
All right. Ms. Kuhn, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Then to the allegation that you violated your bond by violating the no contact order between the dates of December 15th and January 1st, how do you plead? All right. Did you know that there was a no contact order in place?
Yes,
And did you in fact have some sort of contact with the protected person between December 15th and January 1st?
yes,
Did that knowing that that was in violation of your bond condition?
yes.
All right. Ms. Lawrence, do you believe the defendants provided a factual basis to accept the plea to the bond violation?
Yes.
Mr. Piechnik?
Yes.
All right. As does a court, I find that the defendant is in violation for a bond. Mr. Piechnik, I'll turn to you as to whether or not you want to give explanation now, or if you want to address your bond motion.
They're kind of intertwined, so I'll start with it now and then get to the bond motion. You'll have heard it already.
Okay.
But Ms. Kuhn and the alleged victim in this case, Mr. Spohr, began dating 3 years ago.
Okay.
Approximately 1 year ago, he turned violent when he kicked in her front door, forced her into the bathroom, and basically assaulted her, causing damage to her home. There's been criminal proceedings resulting from that. And he was ordered to pay some restitution. They broke up at the time, and then this was in about January of 25, or roughly about a year ago. Since then, they were been on again, off again. And at one point, she moved into his home for approximately a month, moved back out again, and back in again, back out again. So I tell the court that just to kind of get a context of the nature of this relationship. It soured when she had moved in the second time, and he had accumulated cameras. He'd been putting cameras up everywhere. And then when they started showing up inside, quite frankly, and I concur with it, she just found that creepy. And so she took the cameras down, and that actually is the underpinning of what gives rise to her current charges are those cameras. She moved out, and the court issued a no contact order. Since then, the alleged victim in this case has been contacting my client in an attempt to win her affections back, and also in an attempt to basically bait her into violating this court's order. If the court looks closely at the text message that's provided in support of the screen print there, in support of the warrant, if you look, it's him on the right. The right is him. He opens the communication with a sentence. She responds back. Now, see, right at that point there, she has this Sophie's choice. Do I respond back and knowingly violate this court's order and face the wrath of this court? Or do I ignore him and potentially have him show up here, kick my door in again, and then who knows what, take it to the next level? So you can see her response is very terse. TY. Couldn't be any shorter. In fact, he comes back again. And granted, that second time, then she probably adds a little bit too much in there, but the point is that he is contacting her. He has called her as recently as January 6th of this year. He called her. He's taunting her on Facebook saying there's going to be a warrant out for your arrest. You're going to jail. He's taunting her. He showed up at her house in December to shovel her driveway, and then said some things, and he's caught on video. She has a video saying you're going to jail. So basically, he is using this court's order to try to tempt her or taunt her into violating it for the purposes of exactly why we're here today. And that's wildly inappropriate. So our motion is asking for a reciprocal no contact order. So she has, when she gets placed in that Sophie's choice of, what do I do? She has recourse. She can pick up the phone, call the police and say, look, he's not supposed to be contacting me. I need help here. Because if I ignore him, I don't know if he's going to show up here at 2 in the morning and kick my door in, and who knows what happens. So that's why, that's our explanation together with our bond motion. And I think it's well documented where he is the one that is initiating these things.
What authority do I have to grant your request?
Well, that's the thing. And here's the thing is Mr. Spoor has subjected himself to this court's jurisdiction when he, on his own accord, reached out to the police and said, look, I would like these charges brought. So he has placed himself in the jurisdiction of this court by seeking redress from your court. He has petitioned this court for redress. He has said that this alleged crime has taken place and I want you, Your Honor, to manage this dispute. And therefore, he has subjected himself to the jurisdiction of this court. Because he's subjected to the jurisdiction, you have the equitable power to issue the order to say, look, no contact.
But he's not subjected himself to the jurisdiction. The people of the state of Michigan has. He's just a witness in the case, correct?
I respectfully
And a
disagree.
victim.
The case is being brought by the people of the state of Michigan, but he is the one that initiated it when he called and he made this complaint. And he makes these out. These are only allegations. He has said to the police, I allege that my client did this. I want something done about it. So then the people of the state of Michigan have brought the case here before you and said, look, on behalf of this citizen, Mr. Spoor, who has brought this to us, we believe that this occurred and we would like you to adjudicate it. And in my opinion, and my belief, that subjects him to the jurisdiction of this court, not only as a witness, but as a complaining witness. And at the end of the day, the principles of equity lie here. If he's going to continue to basically tease her, taunt her with this, knowing his history of violence, it's just simply unfair to my client to have this no contact order in place. Only one way, because it puts her into this just terrible position of, what do I do here? If I ignore him, we know what he's capable of. And if I attempt to appease him, I'm going to have to answer to Judge Wiggins.
Give me just a second. I want to look at the.
I might add too, Judge, that if we were to issue a no contact order, he certainly has the right to come in front of you and challenge that. Challenge your jurisdiction there. It'd be the same as like a PPO type hearing.
Well, but that's what I'm getting at. What you're essentially is asking for a personal protection order, because when I look at the rules regarding pretrial release, which is 6.106, all those discuss are what I can do with the defendant to ensure compliance, safety, return to the court. You cited, I think it was 7.209, giving broad discretion, but again, that's in appeals, which is what we're not at.
But also, it's not prohibited. And I would argue that conduct not prohibited is permitted.
But what authority do I have? What statute or court rule can you point me to that says I have the authority to restrain a witness or a victim through a condition of the defendant's bond?
I can see that I failed to persuade you, and I do appreciate you allowing me to make the argument. I cannot cite you to any particular statute or court rule because we both know it would be nice if there was one, for sure. But there isn't, but there's a lot of gray area. General principles of equity, the doctrine that if that is not, which is prohibited is permitted, and just general fairness.
But do you have any support for that position, saying that my equity powers in the criminal case, which admittedly are limited in a criminal case, can extend as far as essentially issuing a personal protection order through a reciprocal bond condition?
No, because unfortunately, what usually happens is she goes up to the counter and gets a BDO.
Exactly. Yeah.
So, but again, Ron, we're shifting, and this is where I kind of have to take exception to shifting the onus on her. She could have to go out and do this. She was accused of this and has no burden whatsoever to prove her innocence, or she doesn't carry the burden here. The burden is more and more is being shifted onto her. That's where I have. That's right. But I say I failed to persuade you, but I do appreciate the fact that you allow me to make the argument.
All right, Ms. Lawrence, do you have anything to weigh in on?
Your Honor, I don't think I have a whole lot to add. I think regarding the bond violation and the defendant's bond, I will leave that up to the court. I hate to say this, but unfortunately, this happens in a lot of our cases. The defendant and the victim are constantly communicating with each other. Sometimes our victims become our defendants and vice versa. But that is not an excuse to violate the court's no contact order. As the court said, I do think if the defendant wants to get a PPO, that is completely her decision, but I don't think the court can order a reciprocal no contact order in this case. So I will leave that up to the court. Thank you.
All right, thank you. Mr. Pieknik, do you want to respond to that at all?
I believe you sufficiently understood the overarching circumstances of the issue the client faces, and I'd ask that when you're determining the sanction against my client, that the argument that I made in support of my motion be factored into that, so I don't have to basically repeat it.
Sure, okay. Well, the court will address the defendant's request for reciprocal no contact order. I don't believe I have the authority to do that, and neither defense attorney has not pointed me in a direction to indicate that I do have the authority to do that. So I'm going to deny that request. When it comes to the bond violation and a sanction for that, I'm not going to sanction the defendant. I understand the situation that you were in. I understand that a lot of these times, especially when we're dealing with domestic situations, sometimes it is better to respond than not to respond. However, the court does consider it a violation, and there are other avenues you can go through. I'm not giving you legal advice, but you've heard us discuss a personal protection order. That's something that you could always reach out to and try to get. I'm not going to modify the terms of the bond order. I'll keep the order as it is. I will keep you out on bond. Just keep in mind, though, that next time it happens, I might not have the same view on that. All right. Okay, you can go out to the front window where you checked in, get your next court date, and just a reminder that your bond conditions continue. All right.
Thank you for your time this morning, Judge.
Thank you.
Thank you so much.
You're welcome.
Harris's counsel.
Maureen Lawrence on behalf of the people.
And I'm Jeff Harrison. I'm here on the end of Ms. Horton. She's joined me at the table.
They're here for a final pretrial. Is there any resolution to this matter?
There is, Your Honor.
There is. It's my understanding the defendant is going to be pleading guilty to count 1, operating with high BAC, as well as count 3, failure to report accident fixtures, and in turn the people will be sentenced to operating off.
Mr. Harrison?
That comports with my understanding.
Ms. Horton, have you heard what the attorneys have said the resolution of this case is? And is that how you wish to resolve it?
Yes, please.
So it's my understanding that you'll be pleading guilty to count number 1 of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700. and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, and reimbursements for the cost of prosecution and governmental expenses. You'll also be pleading guilty to count number 3 of failing to report an accident to fixtures. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. In exchange for that, the people will be dismissing the operating while intoxicated, which is a 93-day misdemeanor. Now, do you understand that the operating with a high BAC that you're pleading to and the operating with while intoxicated that's being dismissed, if this case were to go to trial, the people would not be able to try you on both. They would have to choose one or the other. Do you understand that?
Yes.
Does that have any impact on your decision to plead today?
No.
I don't think I swore you. Please raise your right hand. You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Back on November 20th of this year, were you on probation or parole?
No.
Were you on bond?
No.
Do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and rights to a trial. Did you understand those rights? Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plead?
No.
Has anybody threatened you in any way? And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, or inducements not part of the record?
No.
I am not.
And Ms. Horton, to the allegation then that on or about November 20th, 2025, in the city of Cadillac of Wexford County, how do you plead to count number 1 of operating with a high back?
Guilty.
And to count number 3 of failed to report an accident to fixtures?
Guilty.
In order to accept those pleas, I must have you tell me what it is that makes you guilty. So back on the 20th of November, were you operating a motor vehicle in the city of Cadillac?
Yes.
And prior to operating that vehicle, had you consumed alcohol?
Yes.
How much alcohol did you have to drink?
I do not remember.
Do you remember what you were drinking?
Beer and
All right.
Fireball.
Beer and Fireball?
Yes.
Ms. Lawrence, are there chemical tests to support that plea?
Yes, Your Honor, there was a blood draw done and that came back at a 0.405.
Mr. Harrison, was there stipulation to use the blood draw?
Yes, Your Honor, indeed.
And then it looks like while operating that motor vehicle, you had some sort of accident. It looks like where you damaged a mailbox.
Yes.
And did you fail to report that?
I was pulled over shortly after, so yes, I failed to report it.
The counsel believes defendants provided the factual basis in which to accept the pleas and the court rules have been complied with.
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the pleas are knowing, voluntary, and accurate. Ms. Horton, I find you guilty of operating with a high bodily alcohol content and failed to report an accident to fixtures. Pursuant to the plea agreement, the operating while intoxicated will be dismissed at the time of sentencing. Counsel, I was just provided a copy of a substance use assessment. Have both of you received that?
Yes.
Yes.
All right, give me a moment to review it.
Okay.
All right, counsel, do either of you have any additions or corrections to the assessment?
I do not, Your Honor.
Elocution, well, first of all, Ms. Lawrence, do we have any victim input?
No, Your Honor.
Elocution, Mr. Harrison?
Well, let's cut right to the chase, to the elephant in the room, Your Honor. The outrageously high BAC is exhibited from the blood draw. Even Ms. Lawrence confided to me in the hallway that she thought it was a misprint or that the machine was broken when she read it, as did I. We've since found out that neither one of those is the case. Then you couple that with the assessment that says, she disclosed a 0.39 breathalyzer, but we're gonna classify her as having a mild substance abuse problem. on one hand, it sort of suspends reality to believe that both of those could exist together. But if you really think about it, when this case first hit and I heard that there was somebody with a 0.40 BAC allegedly, my thought that was created in my mind was that it would be some 400-pound guy. And as it turns out, it's a rather slightly built, thin woman who was indeed the subject of that analysis. I think, as I've wrapped my brain around it, I think I understand that this was taken very soon after she had consumed what would be a lot of alcohol for anyone in a relatively short period of time, 48 ounces of beer and 3 or 4 shots of Fireball. I personally hope never to experience Fireball, but if I ever did, I presume it would be very low in terms of proof, but shots are shots and you consume them quickly. I have had multiple conversations with Kendra about this too, because I wanted to ferret out if there was any chance that there was some other issue going on or some other factor involved that we didn't know about. And I'm confident that that's not the case. I think it's truly one of those anomalies that can be explained in a manner that makes sense, but still leaves that lingering doubt in your mind when you hear the explanation. Clearly, she could use some education, gain a bit of knowledge about her relationship with old John Barleycorn here. Anyone that can operate a vehicle, although she didn't do so very well, with that high of blood alcohol content, I think that in and of itself calls for an examination of that aspect of their lives. So I think it would be appropriate, and so does Kendra, for you to place her on a period of supervision here. Simply because that will put her in a position where she's focused on the fact that she needs to severely limit and or eliminate alcohol from her life. Obviously, she can't drink while she's on probation. That's not as difficult as it might be for the average person because she does not seem to have a dependence on alcohol. In fact, she's made statements to me like, I can take it or leave it. You know, if it's available in social situations, that's really the only time I drink. And I believe her, and obviously so did the person that compiled the analysis here. I knew from day one, and I told her this, that was going to be a major concern to the court, and it should be, the number. So we spent a good deal of time, she and I did, trying to come up with a plausible scenario under which we could not explain that away, but perhaps assure the court that this is not the product of someone who was, drinking all day long and worked up to this blood alcohol level. That's not the case, at least at this event. I'm glad the court has taken the time to review the substance use assessment, especially in light of the anomaly it reveals. I would encourage the court to provide her with a period of supervision.
Thank you. Ms. Lawrence?
I don't know if I have much to add there, Your Honor. I agree with a lot of the things Mr. Harrison said. The report does say that she does meet the criteria for an alcohol use disorder, although mild type. Yeah, going back to that 0.405, to be frank, I think most people would be in a coma or dead at that level. So the fact that she is driving a vehicle at that high of a level, I think in and of itself shows the court that there is a problem here. It's extremely concerning. There's several things in her assessment that caught my attention that I think are a little concerning. So I would ask the court to impose 24 months of probation in this case. I will say she has done well on bond, to my knowledge. I don't think she's had any violations, so I do think she's a good candidate for probation. I think the extended amount of time is appropriate in this case, given the absurdly high level she was at, as well as some of the things indicated in her assessment. So I would ask the court to sentence to 24 months probation. Thank you.
Thank you. Ms. Horton, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, thank you.
So how many beers did you have?
I don't remember,
Told the assessor you drank a couple 24 ounces
right?
and a
It
couple,
was 3 or 4, I'm not sure.
couple shots of Fireball.
Fireball,
Were those shots in a shot glass or out of the bottle?
out of the little shooter bottle,
So the actual shooters
Yeah.
themselves. Now, how many of those did you have?
3 or 4 as well.
So I know everybody's seen me up here looking up some stuff because I'll be honest, I've been doing this for a little over 10 years. And not as the judge, but in different roles throughout the system. And you are, if my recollection is correct, the second highest blood alcohol content I have ever seen. And so this is from what I was looking at is the College of St. Benedict, St. John's University. And on here, it says that at 0.35 and up, you have reached the level of surgical anesthesia. Coma is possible. Lungs and heart rate are slowing to the point of stopping, and you need immediate medical help. But you didn't. That causes some concern and raises some issues that I have with these substance use assessments. Because I understand that this is all self-reporting and everybody's on the honor system and nobody wants to truly discuss how much they truly drink. That's just the way it is. But to be a BAC at a 0.405, to be driving, albeit not very well because you took out a mailbox, but you drove to the store, you bought alcohol, and you were on your way back, the way it sounds. And then you remember at least getting pulled over. So that tells me that somebody is more of an experienced drinking than what is being relayed through the assessment. And to come back with a mild use disorder at a 0.405, I don't believe it. I just don't. And, you know, right, wrong, or on me, I just don't buy it. I don't buy that somebody who that doesn't drink a whole lot can get to a 0.4 and function. Especially, I mean, when you think about that, I mean, that's like 40% of your blood is alcohol. I mean, think about that. And as this said, you've reached surgical anesthesia level. You'd be knocked out for surgery at that point, assuming you don't die because you're on the verge of it. So I do feel as though there's the need for some intervention here, given the blood alcohol content, the fact that there was an accident. I do know that we start with the presumption of no jail and no probation in these cases, but that is a rebuttable presumption. And I believe the BAC and the accident gets us over that presumption. So as such, I am going to put you on a period of probation. I'm going to put you on a period of probation for 24 months. During that period of time, you're not to violate any law, report as ordered, not leave the state without permission, and to commit no new crimes. Keep your contact and employment information current. You are eligible for early release. So if you've done everything we've asked you to do at the 12-month mark, you can be released early. During that period of time, you're not to consume any alcohol. I want you to attend the alcohol highway safety education class and victim impact panel. No recreational marijuana, and you'll be subject to testing pursuant to your probation officer. I normally would order daily testing, but to your credit, we don't have any bond violations. So that's a whole nother, I don't understand in this case. So I'm only going to order the random testing pursuant to your probation officer. I want you to follow the substance use recommendations, substance use assessment recommendations, any counseling that your probation officer feels is appropriate, including for drugs and alcohol, and any other programming. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $200 fine, $150 court costs, $150 attorney fee. I'm only going to charge you the 12 months of probation, which is $360. If something happens that you end up staying on longer than that 12 months, you'll be required to pay the $30 monthly probation fee. There is a $100 prosecutor fee and a $300 blood draw to the Cadillac Police Department. Did you?
Yep.
1 day jail with 1 day credit, so you're entitled to a $5 credit towards those fines. Any balance that remains unpaid for more than 56 days will have a 20% penalty added to that, but I am going to waive that penalty while you're on probation.
Thank you.
All right. Anything I missed in a judgment of sentence, Ms. Lawrence? Mr. Harrison?
I don't believe so, Your Honor.
All right. Ms. Horton, you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to, and then you'll need to go downstairs to district court probation and get signed up for probation.
Okay,
All right.
thank you.
Thank you.
Judge, probation had shut down.
Oh,
So report first.
so I've just been informed probation is now closed, so you'll need to report there first thing in the morning.
Okay,
All right.
thank you.
Thank you.